Friends, today's lesson is on rights of minority under the Constitution of India. Introduction. The Indian Constitution ensures justice, social, economic and political to all citizens. The Constitution of India does not define the word minority. The term minorities is used as based on religion or language. The preamble of the Constitution declares that all citizens of India are to be secured liberty of thought, expression, belief, faith and worship, and equality status and of opportunity. Keeping in mind the diversity of the population of India, the rights of the minorities have been spelled out in the Constitution. It has adopted measures for the protection of rights of the religious and ethnic minorities and of the socially and economically disadvantaged classes such as the scheduled castes and the scheduled tribes. The Indian Constitution enshrines various provisions for the protection of the rights and interests of the minorities. In this chapter, we shall examine the various provisions of the Constitution which deal with the rights of the minority. Common domain and separate domain of rights of minorities. The Constitution provides two sets of rights of minority. First set of rights can be placed under the common domain and the second set of rights under the separate domain. The rights which fall in the common domain are those which are applicable to all the citizens of India. On the other hand, the rights which fall in the separate domain are those which are applicable to the minorities only, and these are reserved to protect their interests and identity. The distinction between the common domain and the separate domain and their combination have been well kept and protected in the Constitution of India. Common domain under the directive principles of state policy. The Constitution has made provisions for the fundamental rights in Part 3, which the state has to comply with, and these are also judicially enforceable. There is another set of non-justiciable rights stated in Part 4, which are connected with social and economic rights of the people. These rights are known as directive principles of state policy. And as different from the fundamental rights, these rights are not legally binding upon the state, but as Article 37 states, these are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Part 4 of the Constitution of India, containing non-justiciable directive principles of state policy, includes the following provisions having significant implications for the minorities in the country. 1. Article 38, Clause 2 of the Indian Constitution demands obligation of the state to endeavor to eliminate inequalities in status, facilities and opportunities amongst individuals and groups of people residing in different areas or engaged in different vocations. 2. Similarly, Article 46 states that it is the obligation of the state to promote with special care the educational and economic interests of the weaker sections of the people, besides the scheduled castes and scheduled tribes. Thus, whenever the state makes any law or undertakes any policy or under any circumstances, the above principles should be the guiding force behind its actions. Common domain under the fundamental duties. Part 4A of the Constitution relating to fundamental duties as provided in Article 51, Clause A applies in full to all citizens, including those belonging to minorities. Article 51 Clause A, which is of special relevance for the minorities, stipulates as under. Number 1. Citizens' duty to promote harmony and spirit of common brotherhood amongst of the people of India, transcending religious, linguistic, and regional or sectional diversities. And number 2, citizens' duty to value and preserve the rich heritage of our composite culture. The ideals of secularism, fraternity, and democracy, which are the characteristic features of the Constitution of India, are further strengthened in Article 51 Clause A. It is the duty of every Indian not only to imbibe these values, but also to practice in his or her everyday life. Only then unity of the country, which is remarkably plural, can be achieved. Common domain under the fundamental rights. The Constitution has provided a definite space for both the domains, that is, common as well as separate in Part 3 of the Constitution, which deals with the fundamental rights. Under this section, the rights are divided into two parts, such as A. The rights which fall in the common domain, and B. The rights which go to the separate domain. In the common domain, the following fundamental rights and freedoms are covered. 1. Article 14 endorses people's right to equality before law and equal protection of the laws. 2. Article 15 Clause 1 and Clause 2 prohibits discrimination against citizens on the grounds of religion, race, caste, sex, or place of birth. 3. Article 15 Clause 4 relates to the authority of the state to make any special provision for the advancement of any socially and educationally backward classes of citizens besides the scheduled castes and scheduled tribes. 4. Article 16 Clause 1 and Clause 2 stipulates citizens' right to equality of opportunity in matters relating to employment or appointment to any office under the state, and prohibition in this regard of discrimination on grounds of religion, race, caste, sex, or place of birth. 5. Article 16 Clause 4 endorses authority of state to make any provision for the reservation of appointments or posts in favor of any backward class or citizens which, in the opinion of the state, is not adequately expressed in the services under the state. 6. Article 25 Clause 1 grants the citizens freedom of conscience and a right to freely profess, practice, and propagate religion subject to public order, morality, and fundamental rights. 7. Article 26 endorses right of every religious denomination or any section thereof, subject to public order, morality, and health, to establish and maintain institutions for religious and charitable purposes, manage its own affairs in matters of religion, and own and acquire movable, immovable property, and administer it in accordance with law. 8. Article 27 prohibits compelling any person to pay taxes for promotion of any particular religion. 9. Article 28 endorses people's freedom as to attendance at religious instruction or religious worship in educational institutions wholly maintained, recognized, or aided by the state. Although these are applied to all citizens, these articles envision providing protection and safeguards to the minority in terms of access to opportunity, property rights, religious freedom, and others. Separate domain of minority rights. The minority rights provided in the Constitution, which fall in the category of separate domain, are as under. Number 1. Article 29, Clause 1 stipulates rights of any section of citizens to conserve its distinct language, script, or culture. Number 2. Article 29, Clause 2 stipulates restriction on denial of admission to any citizen to any educational institution maintained or aided by the state on the grounds only of religion, race, caste, language, or any of them. Number 3. Article 30, Clause 1 endorses right of all religious and linguistic minorities to establish and administer educational institutions of their choice. Number 4. Article 30, Clause 2 stipulates freedom of minority manage educational institutions from discrimination in the matter of receiving aid from the state. Number 5. Article 347 deals with special provision relating to the language spoken by a section of the population of any state. Number 6. Article 350, Clause A grants provision for facilities for the instruction in mother tongue at primary stage. Number 7. Article 350, Clause B provides provisions for a special officer for linguistic minorities and his duties. And number 8. Explanation Note 1 under Article 25 grants the Sikh community's right of wearing and carrying kirpans. India's multiculturalism interwoven in the Constitution. The various articles of the Constitution providing rights to the minorities clearly and firmly point out only to one direction, that of a multi-religious, multicultural, multilingual, multiracial Indian society interwoven into an innate unity by the common thread of national integration and communal harmony. By the yardstick adopted by the framers of the Constitution and crystallized into its provisions, the Indian nation is not just a conglomeration of individual inhabitants of the state. It comprises two distinct categories of constituents. The two-tier Commonwealth of Indian nation includes, on one hand, every citizen of India individually, and on the other hand, the multitude of religious, linguistic, cultural, and ethnic groups amongst its citizens. The Indian nation is an enormous co-personality in which the individual citizens are also members of their own respective branches, taking the form of religious, cultural, linguistic, and ethnic groups. And all these groups, like all individuals, have the same fundamental rights to enjoy and the same fundamental duties to discharge. Protective arrangement for minorities, Bal Patil versus Government of India Judgment 2005. Bal Patil versus Union of India is a particular case in which Mr. Bal Patil petitioned the Supreme Court of India to direct the Government of India to declare the Jains as national minorities in accordance with the recommendations of the National Minorities Commission. However, in 2005, the Supreme Court judgment of the three-judge bench comprising of Chief Justice R.C. Lahoti, Justice D.M. Dharmadhikari, and Justice P.K. Balasubramaniam declined to issue a writ of mandamus towards granting Jains the status of religious minority throughout India. The court, however, left it to the respective states to decide on the minority status of Jain religion. The apex court noted that state governments of Chhattisgarh, Maharashtra, Madhya Pradesh, Uttar Pradesh and Uttarakhand have already notified Jains as minority in accordance with the provisions of the respective State Minority Commissions Act. Further, the court said the group of articles 25 to 30 of the Constitution as the historical background of partition of India shows was only to give guarantee of security to the identified minorities and thus to maintain integrity of the country. In other words, the court takes them as protective arrangement for the minorities. The apex court in its judgment felt that the special guarantees and protection to the religious, cultural and educational rights of minorities was guaranteed as a fundamental right in the Constitution in the backdrop of the bloody partition to allay apprehensions and fears in the minds of the Muslims and other religious communities. It stated such protection was found necessary to maintain unity and integrity of free India, because even after partition, communities like Muslim and Christians in greater numbers living in different parts of India opted to live in India as children of its soil. It is said that the minorities initially recognized were based on religion and on a national level, for example, Muslims, Christians, Anglo-Indians and Parsis. However, it had sounded a warning against vote bank politics based on divisive tactics and underlined that constitutional ideal which can be gathered from the group of articles in the Constitution under chapters, directive principles of state policy, fundamental rights and fundamental duties is to create social condition where there remains no necessity to shield or protect rights of the minority or majority. Conclusion. The social pluralism of India, as fortified by the unique constitutional concept of secularism, raises the need for the protection and development of all sorts of weaker sections of the Indian citizenry, whether this weakness is based on numbers or on social, economic or educational status of any particular group. The Constitution therefore speaks of religious and linguistic minorities, scheduled castes, scheduled tribes and backward classes, and makes or leaves room for them special provisions of various nature and varying import. Thank you.